Okay. Hello. Hey there. With reference to the first question, okay. With reference to the adoption and commencement of the Constitution of India, consider the following statements. Constitution of India was adopted by the Constituent Assembly on 26 November 1949, and some provisions came into force on that day itself. For example, the citizenship, elections, these all came on the day itself. Then the date 26 January was chosen for the commencement of the Constitution to commemorate the Purna Swaraj Declaration adopted by the Indian National Congress in 1930, Lahore session. Okay. The Government of India declared 26 November as the Constitution Day, Samibhan Divas, in 2015 as a part of celebration commemorating the 125th birthday of Dr. B.R. Ambedkar. All the statements are correct. So answer is D. With reference to the contempt of court in India, consider the following statements. Article 129 and 215, Article 215 of the Constitution makes the Supreme Court and the High Courts respectively as a court of records. And thereby they have the power to punish the contempt of themselves. Say a court of record is the authority of the court to document any evidence as a legal evidence in the state of India. So as a court of record, the Supreme Court and the High Court of India having the power to penalize any individuals on the grounds of contempt of court. Nidimandra Avamadi. Nidimandra Tripurangundram contempt of court. The criminal contempt are the two types. The criminal contempt, which includes any act of or publication which interferes with or obstruct the administration of justice in any manner, is amounted to contempt. Correct. The power of Supreme Court and the High Court to punish the contempt is derived only from the Contempt of Court Act of 1971 is not correct, because it was inherently possessed with the court of being the court of record. So 1 and 2 statements are correct. With reference to the freedom of speech and the contempt jurisdiction of the courts in India, consider the following statements. 1. Fair and reasonable criticism of judicial decision is protected under the freedom of speech and expression, provided it does not amount to the contempt of court. Correct. Court have consistently held that the contempt power should be exercised with restraints and only if there is a serious interference with the administration of justice. Correct. The freedom of speech under Article 19, Clause 1, Subclause A is an absolute right, not an absolute right. It is subjected to the reasonable restrictions. So 1 and 2 only. 4. In the context of the Indian constitutional laws, the doctrine of eclipse is referred to. Doctrine of eclipse. திரைமறைவு ஒளிமறைவு தத்துவம். Doctrine of eclipse is referred to. Doctrine of eclipse means doctrine of eclipse is referred to the temporary overshadowing of pre-constitutional laws that are inconsistent with the pre-constitutional laws that are inconsistent in the fundamental rights, making them inoperative to the extent of inconsistency. See, doctrine of eclipse and doctrine of severability. The two doctrines applied by the Supreme Court. Judicial review. At the time of the judicial review means judicial review means நீதிமன்ற பரிசீலனை. Judicial review means authority of the court to scrutinize the validity of a law made by the legislature. பாராளுமன்றமோ சட்டமன்றமோ இயற்றிய ஒரு சட்டம் அரசியல் சட்டத்திற்கு ஒத்துப்போவதா என்று பார்ப்பது நீதிமன்ற பரிசீலனை. Judicial review comes under Article 13, Clause 2 and Clause 3 of the Constitution. Article 13, Clause 2, which states any pre-constitutional laws which is inconsistent to the Part 3 of the Constitution is invalid. Article 13, Clause 3 states Parliament cannot make a law that is post-constitutional laws. Any law which is inconsistent to the Part 3 provisions is invalid. So court applied the two doctrines. One is the doctrine of eclipse, திரைமறைவு தத்துவம். Doctrine of severability, முரண்பாட்டு தத்துவம். Doctrine of eclipse, which means any law, any pre-constitutional law which is inconsistent to the Part 3 of the Constitution is invalid but not dead. If that inconsistent provision is removed, the law become operative again. You take, for example, the Land Acquisition Act. The Land Acquisition Act was a pre-constitutional law. The colonial government can acquire the land of our will. Pre-constitutional law. That became inconsistent with the Part 3 fundamental rights, in which Article 19, Clause 1, Subclause F deals with the right to property. That is inconsistent. So that pre-constitutional law, it became invalid, but not dead. 44th Amendment removed the right to property from Part 3 into contract right. So when the திரை விலகிய பிறகு when the inconsistent provision is removed from the Part 3, the law became operative again. That is called as doctrine of severability, that deal with the post-constitutional laws. If a law having certain provisions of being inconsistent to the Part 3 of the Constitution, certain provisions being inconsistent to the Part 3 of the Constitution, but not the other provisions, in which the court apply the doctrine முரண்பாடு. ஒரு சட்டம், ஏற்றப்பட்ட ஒரு சட்டம் சில பகுதிகள் மட்டும் அடிப்படை உரிமைகளுக்கு எதிராக இருந்து மற்ற பகுதியில் இல்லாமல் இருந்தால் அந்த சட்டத்தை பிரிக்கும். The court would separate inconsistent provisions from the consistent and declare that inconsistent part alone as unconstitutional and not the other parts of law. Not the other parts of law. You see, A.K. Gopalan, State of Madras case. A.K. Gopalan was a communist leader. arrested under Defense of India Act. Defense of India Act was challenged in the court as the Defense of India Act provisions are being against to the Part 3 of the Constitution. So the arrest should be considered as invalid. But the court pronounced only certain provisions are inconsistent, but the arrest is valid because other provisions are there. That is the law would be considered as invalid only to the extent of inconsistence. If a law whose inconsistent provisions cannot be separated, ஏதாவது ஒரு சட்டம் முரண் இல்லாத என்பதை பிரிக்க முடியாமல் போனால் entire law is considered as invalid. That is the doctrine of severability. Doctrine of severability. There are three doctrines. Doctrine of waiver, that is not for India. Doctrine of severability and doctrine of eclipse. With the reference to the constitutional status of Vande Mataram and other national symbol, consider the following statements. Constitution of India explicitly mentions the national anthem and the national song in its text. No. Imagine if the Constitution of India mentions Janagana Mana means people will be forgotten Constitution on that day itself. Janagana Mana means closer. Even the chapter close. So Constitution thinkers are very vigilant. Avoided the Janagana Mana. Okay. So it's not mentioned in the national anthem or the national song. Janagana Mana is the national anthem of India, while the Vande Mataram is the national song. Okay. Article 51 makes it a fundamental duty to respect the national flag and the national anthem. Any refusal to sing the national anthem automatically amounts to the contempt of court. Not correct. That is, first one is incorrect, fourth one is incorrect. Answer is, with reference to the citizenship and the domicile of India, consider the following statement. Citizenship means domicile. Citizenship differs from the domicile. Citizenship is a conferment of status. An individual becomes the citizen only. An individual is citizen because he is the fullest member of political community of the nation. He can vote, he can walk over, he can rule, or he can tear the government papers. Okay, that is tear. That is citizen. Domicile means domicile. I'm the citizen of India, but I'm the domicile of Nagar, Chennai. Okay. Domicile means the place of permanent residence. The place of the permanent. Indian constitutional framework is based on the principle of single citizenship, correct? But the Constitution not talks about domicile. Constitution distinguishes citizenship from the domicile and permits the state to prescribe the domicile-based conditions for certain rights and benefits, correct? You say for the TNPSC recruitment of certain portions here, it should be the domicile of Tamil Nadu. It should be the domicile of the Tamil Nadu. Correct. Both are correct. With reference to the sons of soil policies in India, sons of soil, that is, sons of Siman, sons of soil, man in mind, the regionalism, sons of soil policies in India, consider the following statement. Such policies may create a differential treatment between local resident and migrants, raising the concerns under the constitutional principles of equality. Correct. So such policies create hatred. Such policies are constitutionally permissible in the public employment, but it is permissible in the public employment. Only in limited circumstances, and when Parliament make a law prescribing a residence as a condition under Article 16, Clause 3. Correct. Certain public employment, for example, in Telangana, we have the Class 3 and Class 4 posts were confined to the public, reserved for the local inhabitants. with reference to the powers of the Lieutenant Governor of Capital Territory of Delhi. Which of the following statement is not correct? Lieutenant Governor has control over the public order, police, and land in the National Capital Territory of Delhi. Correct. Which one of the following is not correct? Not correct. Not correct. You say, if I forgotten that not correct means, what will I will go for? Incorrect. Incorrect one. So it leads to negative marks. It leads to the negative marks. As in the first session of the discussion, we'll have a first lesson. First lesson is we'll approach the test to avoid negative marks. To avoid the negative marks. One thing that you know, that the negative marks was not because of our negative knowledge. We know, but we act wrongly. Negative marks is because of negativity in execution. Negativity in the execution. How the negative aspects occurred in the execution? Because of oversight. Because of the, I have forgotten that not. Morning also I have forgotten that not. Okay, so just to avoid. So to avoid the negative marks, that means proper reading of the questions. Proper reading of the directions of the question. Direction of the question with reference to the powers of the Lieutenant Governor of the Capital Territory of Delhi. Which of the following statement is not correct? Lieutenant Governor has the control over the public order, police, and land in the National Capital Territory of Delhi. Correct. Lieutenant Governor may reserve certain bills passed by the Legislative Assembly for the consideration of President. Correct. Lieutenant Governor can act independently on the elected governments in certain matters where the discretion is constitutionally conferred. Correct. Lieutenant Governor has the power to appoint and dismiss. No, don't have the power to appoint and dismiss the Chief Minister. Chief Minister is being appointed only on the basis of the majority, that the confidence that is enjoyed in the House. In case of hung assembly in the national capital of Delhi, its discretion takes place. So D is not correct. With reference to the Prevention of Money Laundering Act, Prevention of Money Laundering Act of 2002, which of the following statement is not correct? Enforcement Director is the primary agency responsible for enforcing the provision of PMLA. Correct. The Act deals with the offense of money laundering and the attachment of the confiscation of the proceeds of crime. Correct. PMLA exclusively addresses the offenses related to the terrorist finance is not correct. Exclusively addresses to the terrorist finance. Senthil Balaji never committed any terrorist finance. Only from the Tasmak finance. Okay, so it is not correct. Under PMLA, the offense of money laundering is directly linked to the existence of the schedule of funds. Schedule of funds, that is predicate offense, which generates the proceeds of schedule of funds. Schedule of funds, standalone offense, predicated offense. PMLA categorizes the schedule of funds. Schedule of funds means those offenses that is listed in the schedule of the Act. Listed in the schedule of the Act. That means listed in the schedule of the Act. That is any act of bribe, as like the bribe, as like the counterfeit. That is the schedule of offense. Predicated offense means the offense that is the offense not in the schedule, but leads to schedule offense. Leads to the I received a bribe. I received a bribe from the terror money. From the terror money. I received a bribe from the terror money. But my start of act is bribe. Now my start of act is a bribe. That is predicated offense. That is the predicated offense. Standalone offenses, offense that is a criminal act, but not proceeded to other things. That is standalone offense. So PMLA is a special act. Any person to be detained under PMLA is should carry out the procedures properly. The arrest can be, detention can be done only if the person is directly linked to the scheduled offense. That is under the PMLA. Okay, correct. So here the answer is not exclusively deals with the terrorist finance. Sendil Balaji D. C. Okay. With reference to the mob lynching. See, all the questions for the 10 questions, all are current affairs, behind the current affairs. Important. With reference to the mob lynching and the legal framework in India, consider the following statement. Bharatiya Nyaya Sankita 2023 explicitly recognizes the murder committed by a group 5 or more persons on the ground as race, caste, community, sex, language, and the personal belief as a distinct offense. Can be considered by the court as the rarest of the rare case also. Then the National Crime Record Bureau, NCRB, publishes a separate dedicated annual data set exclusively on the incident of the mob lynching. Not correct. There is no separate annual data list of the mob lynching in India. Correct. That is not correct. In the absence of the specific anti-lynching law, incidents of mob lynching still be prosecuted under the General Criminal Act of Violence, Rioting, Conspiracy. Correct. First statement is correct. Third statement is correct. Second statement is not correct. Answer is B. Consider the following statements. As regard the National Commission for the Scheduled Tribe, it is empowered to investigate and National Commission for the Scheduled Tribes is empowered to investigate and monitor the implementation of the constitutional safeguards provided by the people belongs to the Scheduled Tribes. Correct. Commission can inquire into the specific complaints relating to the deprivation of the rights and safeguards of the Scheduled Tribes. Correct. Commission can issue a legally binding order to the state governments. Commission can issue legally binding order to the state governments for the mandatory implementation is not correct. Commission cannot, there is no legally binding order that the state governments need not to carry over the Commission's orders. Third statement is not correct. 1 and 2 are correct. First and the second statement are correct, and the first statement explains the both are mutually substantiating each other. 1 and 2 are correct. So the answer is B. C. Sorry. With the reference to the power of the National Human Rights Commission under the protection of the Human Rights Act of 1993, consider the following. NHRC can conduct the inquiries into the alleged violations of the human rights and can also take the sumo cognizance of such matters. Correct. NHRC can issue an arrest warrant against the individual. Not correct. NHRC is not a criminal court. NHRC enjoys the power of the civil courts. NHRC cannot issue the warrant warrants. 2 is not correct. NHRC can recommend the prosecution compensation. Correct. NHRC can impose the fine and criminal penalties of the individual found at equality. Can impose fine and criminal penalties on the individuals is not correct. 2 and 4. It is not a criminal court. 1 and 3 are correct. Yeah. Consider the following statement. Statement 1. Under the Indian law, electronic publication or the transmissions of absence material is regulated among the others by the Information Technology Act. Correct. The Indecent Representation of the Women Prohibition Act of 1986 permits, not permits. It's a prohibit. It prohibits unrestricted artistic aesthetic depiction of the nudity. Statement 2 is not correct. With reference to the domicile-based reservations in the education, consider the following statement. Supreme Court recognized that the Indian Constitution envisaged only a single domicile, that is the domicile of India. Correct. Any form of institutional or the domicile-based preference in the admissions can be held to be not correct. No, not correct. For example, the 7% reservation, the NEET for the domicile in Tamil Nadu is upheld. One is correct. One is correct. Two is not correct. With reference to the reforms in the medical education in India, consider the following. NEET was introduced to promote the uniform and merit-based standard in the medical admission. Correct? Correct. NEET was introduced to promote uniform and the merit-based standards in the medical admission. Correct, as interpreted by the Supreme Court. But for DMK, it is not correct. The Constitution mandates permanent regional quotas in medical education. Constitution mandate permanent regional quotas. Not Constitution not mandates any permanent regional quotas. Two is not correct. National Medical Commission to replace the Medical Council of India. Correct. 1 and 3 are correct. Answer is, with reference to the linguistic reorganization of the states in India, consider the following statements. The State Reorganization Commission accepted the language as an important factor in the reorganization of the state boundaries. Correct. Language-based demarcation of the states. Correct. Linguistic reorganization of the states in India significantly intensified the secessionist movement. That is not correct. It is not the linguistic reorganization of the state led to the secessionist movement. Secessionist movement was because of over diet of certain people to secede out of India. That is over diet, excess diet and excess rights. Okay. Because of other reason, that is the A only is correct. With reference to the Indian national flag, consider the following statement. The Flag Code of India 2002 was amended in 2021 to permit the use of machine-made, liberal use of the flags, national flags. Correct. Ashok Chakra in the center of the national flag represented the Dharma Chakra and symbolizes the movement and the progress. Correct. The Constitution of India explicitly describes the design, Constitution not deals with the design and specification of the national flag. 1 and 2 are correct. Answer is D. Preamble can be used as an aid to interpret, but not as a source of the power of the Constitution. Then the preamble is a part of the Constitution and its ideal guide the limits of the amending power of that. Then inserted the word, that is 42nd Amendment, lay down the limits on the misuse of the Article 356 SR Bombay Court judgment. Then the preamble is a part of the Constitution and it's used at the time of ambiguities, that is Keshavananda Bharati case. And preamble can be used to aid and interpret, but not the source of power. That is Berubari case. By that, answer is A. With reference to the Magna Carta of England as the genesis of the Bill of Rights. With reference to the Magna Carta, consider the following statement. Certain provisions of Magna Carta laid the foundation for the modern principles of due process of law. Correct. Due process of law and procedure established by law. Welcome. The rights guarantees under the Magna Carta are intended to apply equally to all the peoples of the United Kingdom on the island of Wales. That is not only for the peasant serfs and the feudal elite, not for the feudal elite. That is 2 is not correct. The first statement is correct. Answer is A. Consider the following statements. Statement 1, right to privacy is an intrinsic part of the right to life and personal liberty under Article 21 of the Constitution was referred by the Supreme Court in the Puttaswamy case. Both the statements are correct. And the statement 1 substantiate the statement 2 substantiate the statement 1. Finance Commission of India, Election Commission of India and its role, Finance Commission of India and its role, UPSC in India and its role, CAG of India and its role. Answer is, you may be knowing more than us. Okay. Article 32, 20, 280 Finance Commission, 356 emergency in the state. Then the 20 deals with the exports factor law. Then the 32 deals with the writ jurisdiction. Answer is A. with reference to the இப்போ ஓவர் சைட்டடாக நான் இங்கே பண்ணும்போது அந்த மாதிரி நீங்கள் பண்ணீங்கன்னா 2ல் 3 கொஸ்டின் பண்ணீங்கன்னா ஒரு நெகட்டிவ் மார்க் வரும். ஓகே, நீங்கள் படிச்சுட்டு பண்ண டைம் வேணாம். ஓகே, அந்த மாதிரி பண்ணக்கூடாது. எல்லாத்தையும் படிச்சு பார்த்துட்டு பண்ணணும். இல்லைன்னா 5 கொஸ்டினுக்கு 1 நெகட்டிவ் மார்க்ஸ் 1 வாங்கிக்கின்னு போட்டது ஒன்றெல்லாம் போகும். Okay, with reference to the Article 14, right to equality under Article 14, consider the following statements. Classifications under Article 14 is valid only if it is found on an intelligible differentia, and such differentia shall have the rational nexus with the objective sought to be achieved. Correct. Article 14 deals with the equal protection of law. Equal protection of law enables the state to classify the classes of people on the intellectual ground, and the classification should have a nexus between objective of the classification and the result to be achieved. That is correct. Nexus between objective sought and the rationality of the classification. Arbitrariness of the state action is antithetical to the equality and may violate the Article 14 even without the formal classification. Correct. Article 14 prohibits all form of legislative. That is not correct. That is not correct. That 1 and 2 are correct. And answer is B. With reference to the personal law and the constitutional scrutiny of India, personal laws and constitutional scrutiny in India, consider the following statement. In the state of Bombay versus Narasu Appamali, in the case of the state of Bombay versus Narasu Appamali, the Bombay High Court held the uncodified personal laws are not the laws in force under Article 13, and hence they are outside the scope of Article 13. I doesn't know that. Okay, in Sayara Banu versus Union of India, the practice of instant triple talaq was examined and invalidated. Correct. And Sayara Banu case, all personal laws are not automatically came to under the scope of Article 13. 2 and 3 are correct. 1 I doesn't know. Let the 2 statements to be correct and give preference to answer B. Some questions we can take risk because it challenges our knowledge and wisdom. One side doesn't know means wrong. I know means right. You pledge your knowledge as a risk. Okay. With the reference to the writ jurisdiction in India, writ jurisdiction, consider the following statement. The writs can be issued against the private bodies if they are discharging the public duties and the public functions. Correct. Even the private bodies, habeas corpus can be issued even on the public as well as the private bodies. Supreme Court can issue the writ under Article 32 only for the enforcement of the fundamental rights, whereas the High Court can issue writs under the Article 226 for the fundamental rights and the legal rights. Correct. Only the Supreme Court has the power to issue the writs or the enforcement of fundamental rights is not correct. Even the High Court or any court conferred by the law of the Parliament. That is 3 is not correct. 1 correct and 2 correct. Under the protection of the Human Rights Act of 1993, National Human Rights Commission is empowered to issue arrest warrants against the alleged violators is not correct. Empowered to conduct the inquiries on alleged human rights violations, including taking sumoto cognizance. Correct. The B statement. Once a statement is affirmably represent our answer means we can skip other statements. Okay, B. With reference to the freedom of press and related judicial interpretations, consider the following statement. Indian Express newspaper versus Union of India case that was held at the time of emergency, where the Indian Express paper was attempted to restrict by the government. That led to the case. Indian Express versus Union of India case, Supreme Court held that taxation measures cannot be used against as indirect measures to curtail the freedom of press. Correct. Sriya Singhal versus Union of India, Supreme Court struck down Section 66A of the IT Act of 2000 as unconstitutional by violating the Article 19, Clause 1, Subclause A. Correct. Shriya Singhal versus Union of India, in which the article, in which Section 66A was upheld by appellee, the doctrine of reading ground is not correct. Doctrine of reading ground, reading down, doctrine of reading down. What is that? Doctrine of reading down. Doctrine of reading down, in which the court applies while at the time of judicial review. Court applies while on the act at the time of judicial review on any law, reading and interpreting such law as it concurring to the constitutional provisions. Concurring to the constitutional provision. Any law which apparently seems to be against to the certain provisions of the Constitution can be read by the court as it is consistent to the other provisions of the Constitution, so the law is valid. Law is valid. When valid, when on the basis of doctrine of reading ground, court upheld the law, don't struck down the law. So 1 and 2 are correct. 3 is not correct. Third statement is not correct. Under the National Commission of the Women Act of 1990, National Commission of Women is not empowered to. National Commission of Women investigate and examine all the matters relating to the safeguards of women under the Constitution and other law, including taking up the complaints and the summative notice of the cases involved the deprivation of the woman's right. Correct. Issue a National Commission of Women issue legal binding direction. No legal binding directions. It intend to promote the women welfare empowerment. Correct. Recommend measures and policy interventions for the women. Correct. D is not correct. Not empowered to issue legal binding directions. B is not correct. Which of the following statement regarding the Finance Commission is not correct? Not correct from the constitutional perspective. Finance Commission recommend the distribution of the tax revenue between union and state is correct. Its recommendations are binding on the government. It's not correct. Finance Commission recommendations is not absolutely binding on the president, on the government. It reports is submitted to the president. It considers the socio-economic factors for its recommendation. Correct. B is not correct. B is the answer. Consider the following statement. In the Indian Constitution, the conflict between the fundamental rights and the directive principles has been addressed to the constitutional amendment and the judicial doctrines. Correct. Article 15, Clause 4 was inserted following by the Chanbagam Durairajan judgment, and the 9th schedule was introduced to protect the land reforms law. Correct. Golaknath case upheld the unlimited parliamentary power to amend the fundamental rights and the fundamental rights, and Minerva Mills case restored the doctrine of harmonious construction. Golaknath case upheld the unlimited power of parliament to amend the fundamental rights is not correct, because Golaknath case is to restrict the power of parliament for the first time. In 1967, Golaknath case was known for two important aspects. One is Golaknath case established fundamental rights as a transcendental status. Parliament cannot amend the fundamental rights, and fundamental rights enjoys the transcendentality. To amend the fundamental rights, it need another constituent assembly. Golaknath judgment states that Justice CJI at that time, Justice Subbarao stated that if you like to amend the fundamental rights, you need another constituent assembly. So the Golaknath case, known for the importance, it recommended the requirement of the new constituent assembly, because fundamental rights was considered as transcendental. Second, Golaknath case is important because for the first time the court reversed the judgment and pronounced the doctrine of prospective overruling. Prospective overruling. That means the reversed stand of the court. The reversed stand of the court shall be effect only in prospective, with prospective of the day of execution. Until reversed stand over. That means the act done and omitted to done. before that stand shall have no effect with the new stand of the court. That is two aspects. That is, one is a recommendation for reconstituent constituent assembly, fundamental rights as transcendental. Then the second one is doctrine of prospective overruling. The statement 3 is incorrect. Okay, 1 and 2 are correct. So answer is C. With reference to the mob lynching and the judicial direction, Bharati and IAS Sankita describes the death penalty as a sole punishment for the bomb lynching resulting in murder. Not correct. Not the sole punishment. Then Tehsin Poonawalla guidelines focused exclusively on punishing measures. Not correct. It deals focus on preventive measures, remedial measures, compensatory measures for the victims. Court guidelines, as like Visakha guidelines for the sexual harassment of women in workplaces. Nirbhaya guidelines for rape, deal with the rape. D.K. Basu guidelines for detentions. In SABE, it is the guidelines for mob lynching. The Supreme Court reaffirmed the binding nature of the guidelines while declining to fix the uniform compensation. Correct. National Crime Record Bureau has consistently published the separate, not the separate mob lynching case. So, first one is wrong. Then second one is wrong. Third one is right. And third one is right. Answer is C. 3 only. C. 31. With reference to the obscenity laws in India, Bharati and IAS Sankita primarily governs the online obscenity. Primarily governs the online obscenity. Not correct. Obscenity means general obscenity. Then Avik Sarkar 2014 adopted the community standard test. Obscenity means any publication is obscene in nature is dependent on the standard of our community. For example, you take in nudity. Indian standard of nudity is different from the Western standard of the nudity. Western standard of nudity, nude is full nude, is acceptable, but not the Indian standard. That is community test. Hicklin test is suggested, not applied. It is adult standard, not applied. Navtej Johar submitted the constitutional morality subordinated Navtej Johar case subordinated constitutional morality to the party. That is not correct. Nowhere in the court always prevails, gives importance to the constitutional morality. Constitutional morality is the supreme. Then the public morality, religious morality, you say Sabrimala case, religious morality, spiritual morality, religious morality, but constitutional morality is supreme than the honor. So fourth is not correct. Then the 3 is not correct. 1 and 2 are correct. 2 is correct. 1 is not correct. 2 is correct. With reference to the right to property, consider the following statements. Shankari Prasad case 1951 held that the constitutional amendments are not law under the Article 13. So can amend the Part 3 of the provisions. Correct. Article 31B to protect the 9th schedule laws from the challenge in the court. Correct. Keshwananda Bharati case held that the right to property is not a right to property. That is not correct. Not correct. 3 is not correct. Then 1 is not correct. 3 is not correct. 44th Amendment made a property as a legal right under Article 300A. 4th is correct. 4th is correct. So 2 is correct. 4 is correct. 2 is correct. 4 is correct. 1 is correct. 1, 2, 4. A. With reference to the writ jurisdiction, consider the following statements. National Bureau of NBFC, non-banking finance companies. Non-banking finance companies automatically fall under Article 12. Not correct. Article 12 definition of the state. Non-banking finance companies were actually legal citizens. Not correct under the state category. Then private bodies performing the public duties may be subject to the writ jurisdiction. Correct. High courts may refuse the writ relief to inappropriate cases. Correct. Parliament can empower the court to issue the writs. Correct. 2 correct, 3 correct, 4 correct. Answer is C. Consider the following statement with reference to the right against self-incriminating evidences. Right against the self-incriminating evidence under Article 20, Clause 3. That means the right against compulsion of evidences. Compulsion of self-incriminating evidence does not apply to the fingerprints. A person cannot claim immunity from giving the fingerprints. Then it is applied to narco analysis. Narco analysis means applying some narco drugs, applying something narco. A person won't tell the truth, so some narco drugs like the sodium pentothal, like that drug is applied. Then asked, "What is your real name?" He tells the real name. That is called as narco analysis. That is very that existed up to that prevailed in India. That prevailed in the India is to avoid the third-degree tortures. Avoid the third-degree torture. There was a CJA called as Balakrishnan. He told that that type of applying a drug is just like raping the mind. So he declared that is violating the fundamental rights. So people started custodial death. First, before that, there is a simple injection, then questions. The person would give the answer. And so the court has came out with a new stand, that is narco analysis as against the fundamental right, and narco analysis should be made only on the special conditions. Then any information from the narco analysis cannot be treated as evidence, can be treated as a lead to evidence. Yeah, so what the policeman do? Once again, he has taken lattice. See, it does not appear to the fingerprints. See, people's escapes. People's escapes. Today, that Villatikulam criminal, rape criminal was apprehended. That Villatikulam rape criminal was today. The flash news today is afternoon is, and the Villatikulam rape criminal was caught. While inquiring to the criminal, that is 24 hours duty was committing rape. He has already committed the rape of 70 years old, 60 years old woman. Then came back. Then is 24 hours duty is a professional of committing rape, theft, murders. It is his whole profession. Whole profession. He is having 30 FIRs. 30 FIRs. Because no FIR proved him. Because no narco analysis. That Justice Balakrishnan is responsible for this. Okay, no narco analysis. Narco analysis. Then criminal procedure code, Criminal Procedures Identification Act limits the collection of convicts only. Not correct. For the investigation, the collection of evidences to be made from any. Compelling voice samples violate Article 2003. Not correct. Compelling voice samples. Compel as a voice samples. If a person, a mafia don, threatened the person died, voice sample is important. Correct. So 4 is not correct. 3 is not correct. Then the 1 is not correct. Then இதுதான் correct. 4 is not correct. Okay. Compelling voice samples violates 4 is not correct. 3 is not correct. 1 is not correct. Forced narco analysis violates, that is correct. 2 is correct. 2 is correct. Okay. Which of the following statement regarding the National Commission for Women is not correct? In the correct, not correct, konjam telivaikkanum. Okay. Okay. Not correct, correct. Adula nam question la poi correct, not correct. It can examine the National Commission for the Women can examine the safeguards for the woman under the Constitution, correct? It may intervene in the court cases involving the women's rights, correct? It has the power to summon the individuals for inquiry, correct? It can no, it cannot initiate legislations. That is not correct. Consider the following statement with reference to the halal certification and constitutional offices. Halal certification and the constitutional law. Mandatory halal certification for all products was supported by the Solicitor General. No. Okay. Director General for the Foreign Trade regulates the halal certification for the meat exports. Correct. Because some Gulf countries demands the halal certification for the meats. Correct. That was regulated. It is a trade regulation. India lacks a unified national halal certification framework. India is Pakistan now. India is not Pakistan. Okay. 1 and 3 are not correct. Solicitor General is appointed under Article 76. There is no such post in the Constitution stating Solicitor General. It is only Attorney General. Only Attorney General. Solicitor General, additional Solicitor General are created by the government. So 4 is not correct. 4 is not correct. 1 is not correct. Then 2 is correct. 3 is correct. 2 and 3 are correct. Answer B. Consider the following statement about the Indian Constitution. Indian Constitution provides the exact strength for the Council of Ministers at the center. No. In a constitutional amendment, introduced the ceilings of the size of the Council of Ministers based on the judgment. That means the size shall not go beyond 15% of the total representation in the Lok Sabha. That is applied to the state also. That was 2 is correct. 1 is not correct. With reference to the Constitution of India, consider the following statement. Right to property is still recognized as a constitutional right. Legal constitution. It is not a fundamental right, but a constitutional right. Article 300A is a contract right. It's mentioned as a constitutional provision, so it is a constitutional right. The constitutional right of legal lines, legal standards. It is not a fundamental right, constitutional right of fundamental standards. Okay, it is correct. A person can be deprived of his property except only by the authority of the law. Correct. Cannot be deprived of property except by the authority of the law. Correct. Cannot be deprived of the property except by the authority of the law. Correct. Right to property is still recognized as a correct. Both are correct. With reference to the Muslim rights, Muslim women rights to maintain unrelated judicial developments, consider the following statement. Muhammad Ahmad Khan versus Shabanu case, the Supreme Court held that the section 125 of the Criminal Procedure Code applied equally irrespective of all religions. Correct. The Muslim Women Protection of Rights and the Divorce Act of 1986 confined a husband's liability to provide maintenance strictly to the Idat period. Idat period, that means 2 menstrual period. After divorce, talak, he has to give only the 2 compensation. That is correct. The Daniel Latifi on the Union of India case, the Supreme Court struck down 1986 Act as the unconstitutional. 1986 Act as the unconstitutional. The 21st Law Commission of India recommend the immediate. No, not correct. 4 is not correct. 1 is the 1 is correct. 2 is correct. 3 is not correct, and 4 is not correct. 1 and 2 are correct. Answer is B. With reference to the bonded labor in India, consider the following statement. Article 23 of the Constitution prohibits forced labor, which includes the bonded labor, bekar, bonded labor. Okay. Adolescents are completely prohibited from the employment under the labor laws. Not correct. In some industries, there are certain industries, special industries, slate industry, carpet weaving industry, adolescents employed. Correct. Completely prohibited is not correct. 1 is correct. 2 is not correct. A weak interstate coordination that severely affects the bonded labor prohibition laws. Correct. Bonded labor arises exclusively from the debt-based arrangements. Correct. Exclusively from the debt-based arrangement. Not exclusively, only from the debt. Only from the debt-based arrangement. 4 is not correct. 3 is correct. 2 is not correct. 1 and 3 are correct. 1 and 3 are correct, but the options are not correct. Okay. Let you give some privilege to make us correct. Okay. See, with reference to the union budget of 25-26, this is also not correct. Union budget but it is correct in the grounds of governance. The grounds of the governance. Though it is economy, in a maximum load limit under Kisan credit card scheme as announced in the union budget to 30 lakhs, not the 10 lakhs. Pradhan Mantri Dan Dhanya Krishi Yojana was a pilot scheme of 100 districts. Not correct. Maritime Development Funds with allocation of 25,000 crore was announced. Correct. To promote blue economy. Urban Challenge Fund of 50,000 crores. Urban Challenge Fund of the 50,000 crores. 50,000 crores. But one thing is correct. Maritime Development Fund of allocation of 25,000 crore. Correct. So by the answer, only one options are given. So 3 is not correct. I'm risking my knowledge. Okay. Pledging my knowledge. Okay. Match the following. 3 only. Match the following. 42nd, you have to answer. 42nd Constitutional Amendment, 44th Amendment, Article 21, and Article 104. The 104 Constitutional Law. 42nd, ensured Article 20 and 21 cannot be suspended even at the time of emergency. 44th Amendment. 44th Amendment as the impact of the habeas corpus case. Habeas corpus case in which the court the 44th Amendment. That means Article 20, 21 and Article 32 Clause 1, habeas corpus, cannot be suspended. Then 42nd Amendment that deals with the insertion of the socialist secular integrity in the preamble. Then Article 21, the post Maneka Gandhi judgment, deals with the procedure established by law as interpreted as due process. What is the procedure established by law and the due process of law? Procedure established law. சட்டத்தின் வழிமுறைப்படி. Due process of law. வழிமுறையான சட்டத்தின்படி. Language is good, but meaning is confusing, isn't it? See, Article 20 or 21, which states that state shall not deprive an individual right to life and personal liberty without the procedure established by law. Article 21 states the state shall not deprive the right to life and personal liberty of an individual without the procedure established by law. That means a personal right to life and personal liberty cannot be violated by the state without certain established procedures. Only with that means the court. That means the state can violate. State can detain a person with the established procedure. Established procedure. You take for example. Section 144. Section 144 declared in a place. For example, in Nagar. Section 144 means Section 144 போட்டிருக்கானுங்கன்னா என்னது நம்மள புடிச்சுன்னு போயிடுவாங்க. இது பப்ளிக் பிளேஸ்ல திரும்ப இருக்குன்னா Section 144, that means assembly of more than 4 persons is offense. Assembly of more than 4 persons. It establishes the procedure. Section 144 should have the procedure that it should be declared only by the district magistrates, collectors, or commissioner of police. Procedure. It requires detention to have 4% minimum. 4 பேர் இருக்காங்க, போலீஸ் வந்து பிடிக்குது, ஒருத்தன் எஸ்கேப் போயிட்டான்னு வச்சுக்கோ, அதை கேஸ் போட முடியாது. நான் ப்ரொசீஜர் 4 பேர் வரணும். ஜட்ஜி கேட்பாங்க, யூ arrested under section 144, only 3, there is 4, so arrest is invalid. That means the procedure established by law. That was followed. That means authority of the court shall verify the constitutionality of executive actions. Constitutionality of the executive action, that is called as doctrine of procedure established by law. This doctrine was followed in the UK Constitution. UK Constitution. But in Menaka Gandhi case, in 1982, Menaka Gandhi case, court has shifted to the new doctrine called as due process of law. Due process of law, doctrine of due process from the US traditions. Doctrine of due process, the court verified even that established procedure fulfill the principle of natural justice. Fulfill the principle of the natural justice. So doctrine of due process, court shall verify not only the executive action, but also of the intention of the legislature and the draft of the legislature, called as doctrine of due process. Court stated that doctrine of due process is implicitly mentioned in the Article 21, because right to life means a right to life and liberty can be ensured only with fair procedures. Only with the fair. Court shall verify that procedure also. The procedure should be fair, and the procedure should fulfill the principles of the natural justice. That is doctrine of procedure established by law under Article 21. Then Article 104 constitutional amendment that deals with the extension of reservation for the Anglo-Indian communities in the legislature. Answer is A. With reference to the place of worship, Special Provisions Act of 1991, Shaki Jama Masjid at Sambal is notified as the protected monument under the Act, not protected. Shaki Jama Masjid in Madhya Pradesh is protected comes under the Religious Worship Act. Yes, Section 5 of the Act exempts only the Ram Janmabhoomi. That the Places of Worship Special Provisions Act of 1991 frees all the places of worship in the condition as it existed in 1947, but given the special exemption to the Ram Janmabhoomi place because of case pending in the court at that time. Correct. Court may examine the religious character of the places of worship in broader circumstances, in historical circumstances. That is not correct. All disputes settled prior to the commencement of the Act were abated under the Section 4.2, correct? 4.2 of the Act. Places of Religious Worship Act of 1991 was legislated to give the status quo conditions of the religious worships as it existed in 1947. So the 4 is correct. 4 is correct. 2 is correct. 2 and 4 is correct, and 1 and 3 is incorrect. Consider the following statement. Indian Constitution follows a system of functional overlap among the legislature, executive, judiciary, rather than strict separation of power, and incorporate the system of checks and balances. Functional overlap, executive, legislature, judiciary. Any example? Any example that the parliament functions as a court? Court functions as a parliament. Any example that the parliament functions as a court? Impeachment of the judges of the Supreme Court and High Court, where the parliament functions as a court. Then court functions as a parliament. Judicial guidelines, Visakha guidelines, court functions. So Indian Constitution follows a system of functional overlap. Correct. Article 122, Article 212 restrict the judicial scrutiny. Article 122 establish Parliament as supreme in its own domain. In its own domain, in which the court cannot interfere. Court cannot interfere into the Speaker of the Lok Sabha action of why you suspended some members. Court cannot interfere. Parliament is supreme in its own action. So Parliament, state legislature is supreme in our own domain. Article 122 and 212 restricts the judicial interference in the legislative procedures of the Parliament and the state legislature. Correct? So statement 2 is correct. Statement 1 is correct. Both the statements are correct and substantiating with each other. Answer is A. Okay. With reference to the doctrine of separation of powers in India, consider the following statement. Indian Constitution adopts a system of functional overlap rather than strict separation of powers. Correct. Indira Gandhi versus Indira Nehru Gandhi. Then why Gandhi? Indira Nehru. Why Gandhi? Indira Nehru Gandhi. Indira Nehru Gandhi versus Raj Narayan case in 1975 deals with the misuse of public office and the violation of People's Representation Act, not of absolute legislative supremacy. Raj Narayan was the opposition leader, and he challenged Indira Gandhi that he will commit the next shave only after defeating Gandhi. Only after defeating the Indira Gandhi. In the case, he defeated Indira Gandhi. That is Indira Gandhi versus Raj Narayan case. Very famous at that time. Then Article 122, Article 212 restrict the judicial. That is correct. Power to pardon. Power to pardon is one again overlapping of function. Power to pardon ordinance. Power to pardon is the president. Presidential power to pardon. Why president powers the power to pardon? Power to pardon that possessed by the president is to annul some judicial errors. To annul the judicial errors. Then the president ordinance means ordinance power of the president is an executive. Ordinance is a law. Ordinance power of the president is overlapping power. That is executive come legislative power. Executive come legislative power because president applies because when the parliament is not in function, when any house of the house is not in function, but we need a law. We need a law. That is that represents the checks and balance. 2 is not correct. 2 is not correct. 1 is correct. 3 is correct and 4 is correct. B. With reference to the land allocations, land allotment and the constitutional doctrines, consider the following statement. Arbitrary land allotment of the state may violate Article 14 of the Constitution. Correct. Arbitrary, Tannichayana, Nila violates Article 14. Correct. Court have applied the doctrine of colorable exercise of power in the land allotment case. Court have applied the doctrine of colorable exercise. Doctrine of colorable exercise, which means doctrine of colorable legislations. Doctrine of colorable legislations. That means what you cannot do directly, doing indirectly. What you cannot do directly, doing indirectly. That is called as doctrine of colorable legislations. That means in different color. In different color. What for example, I will say the state government has the state legislature has the power to levy toiletries, power to tax the toiletries. With this power to levy the toiletries, state can sometimes apply this power to levy on any of the products that comes under the union list. In the name of regulating the money lending, state if the provision of the state law attempt to regulate promissory notes means colorable legislation. His aim is to encroach that power. So what you cannot do directly, that you do indirectly. That is the doctrine of colorable legislations in the power. That means the state aim is to develop some land and to give to his chief minister's family. But applying the law applying the law of converting that forest into resorts for the people. Converting that the public lands into the individual lands and enabling the individual land to be sold to the master. That is colorable legislation that the court applied. Public trust doctrine has been invoked to restrict the state. Is correct. 2 correct, 3 correct, 1 correct, 1 correct. The discretion of the state in land allotment matter is not absolute. It's not absolute. 4 is not correct. So all the statements are correct except the 4th statement. With reference to the human trafficking laws and institutions, consider the following statement. The ITBP, that is Trafficking Prevention Act of 1956, mainly addresses the trafficking of sexual exploitation. Correct. UNTOC, United Nations Trafficking Control, defines organized criminal group and also organized crime of human trafficking as an organized crime. That's also wrong. The second statement is wrong. ATHU operational unit. We will see. We'll see after. Okay. After getting into the service, we'll go through what is AHTU and OCI. Okay. Skip 48. We'll do. With reference to the minority status of Aligarh Muslim University, consider the following statement. Recently, the problem occurred. Genesis of an institution is important to determine whether it was established as a minority institution under Article 30. Correct. A minority educational institution must admit and educate only the minority. Not correct. Not correct. It is a preference to the minority students. Then Supreme Court has conclusively declared Aligarh Muslim University not as a minority. It is a national institution. So 3 is not correct. 3 is not correct. Then 2 is not correct. 1 is correct. Under the constitutional scheme governing the elections in India, enforcement of Model Code of Conduct primarily derives the legitimacy from which of the following principle? Model Code of Conduct came into force based on the consensus of the political parties from 1967. Based on the consensus of the political parties, the Election Commission of India drafted the Model Code of Conduct. What are the Model Code of Conduct? Any provisions of Model Code of Conduct? Any provisions of the Model Code? It prohibits the state governments. It permits the governments to come out with any development schemes. Any development schemes. Then it prohibits any of the financial exchanges, the use of finance for the electoral gains. Then it prohibits any act of the government, misuse of the government bodies. These are all Model Code of Conduct. Model Code of Conduct comes in effect with the announcement of elections. With announcement of the elections. With announcement, if you carry the big bag now in the Nagar, you will be checked because Model Code of Conduct is there. Model Code of so this Model Code of Conduct comes in operation based on the following principle: freedom of speech and expression, no; separation of powers, no; it is rule of law. It's a rule of law. As the Election Commission of India and Government of India considered the drafted consensus to have the validity of the law. So it is the rule of law. 51. With reference to the Central Information Commission, the Central Information Commission is a statutory body, and the removal of the Central Information Commission follows the same procedure as prescribed by the judges of the civil. Not correct. Not correct. Central Information Commissioner can be removed by the government. It is not correct. Then the commission enjoys the power of the civil court, but it does not have the power to punish of the contempt. Correct. Central Information Commission submits its annual report to the President. Correct. President of India. 2 is correct. 1 is not correct. Then 2 is correct. 3 is correct. One is not correct. Consider the following statement. There have been an important developments in the recent years relating to the appointment and service conditions of the information commissioners under the Right to Information framework. Correct. The Right to Information Act of 2019 fixes the tenure and services conditions of the information. Not correct. Act not fixes the tenure. The Anjali Bharadwaj versus Union of India Supreme Court directed that the criteria for shortlisting the candidates for the appointment as the Information Commissioner should be disclosed to the public. Should be disclosed to the public. Should be disclosed to the public. Not correct. So one only correct. Answer is D. Okay. Consider the following. In India, the preparation and revision of the electoral roll requires the verification mechanism that was distinct from the countries having the comprehensive civil registries. Correct. An intensive revision involves the fresh enumeration of electorals, unlike the summary revision. Correct. Summary revision means update. Intensive revision means revise, entire revision. Correct. Unlike the countries with the civil registry, India requires the independent verification of the voters by the election commissioner. Correct. 2 correct, 3 correct. The first correct. 1, 2, 3, all the statements are correct. The 2 statements are to substantiate the statement 1. So answer is yeah. Okay. Statement 1. In a special SAR, in the special intensive revision of the electoral rolls, the Election Commission adopts a measure to improve the accuracy and the integrity of the voter list. Correct. During SAR, the enumeration forms and the supporting documents are digitalized to enable the verification and reduce duplication. Correct. During SAR, representatives of the political parties as the booth level agents are being involved in the verification process. Correct. All the statement correct. Answer is A. 55. Consider the following statement. National Commission for the Minorities is a statutory institution intended to safeguard the interests of the minority communities through an advisory and the monitoring role. Correct. National Commission of Minorities involved from initially a non-statutory. Correct. That is also correct. Initially, it was established as a resolution of the parliament, not by law, and later it was given the legal status. Then the recommendation of the National Commission for the Minorities are advisory in nature, not legally binding. Correct. All the statements are correct. With reference to the constitutional safeguards for the minorities, consider the following statements. The Constitution of India does not define the term minority. Correct. Does not define the term minority. It deals only with the religious and the cultural rights for those peoples categorized minorities by the governments. Jains were notified as a minority community from 2014. Correct. National Commission for the Minorities is the sole authority, not the sole authority of enforcing Article 30 safeguards for the educational institution. Then National Commission of Minorities is a statutory body that reports to the central. Correct. 4 correct. 2 correct. 1 correct. 1 correct. Second statement is a risky statement. It deals with the fact. In 1990s itself, they were separated from the Hindu category. Separated from the, so it is correct. It is not correct. 1 and 4, first correct, then the 4th correct. 3 is not correct. The Jains were notified is a doubt. So in total, the question is not absolutely correct. Note on, we'll rectify. With reference to the powers and functions of the governor, consider the following statement. The governor's power to summon the assembly is absolute discretion. No. Should be based on aid and advice of the Council of Ministers of the state. Punchi Commission recommended the removal of governor as a chancellor of the state university. No, the commission not required. Then the Supreme Court fixes a strict 6 months deadline for the assent of bill. No, it was removed by subsequent judgment. Unreasonable delay by the governors on the bills can attract the judicial review. 4th is correct.
Fourth is correct. Then the 1 is not correct. Then 2 is not correct. 3 is not correct. Only one statement is correct. Okay. Which of the following in the area எல்லாம் நம்ம வேற வழியில் only one statement is correct and போட்டு போயினார். Okay. Which of the following commission recommended that the removal of the governor should ordinarily involve the ordinarily removal of the governor should be involved with the consultation with the chief minister of the state. It is Sarkaria Commission recommended the appointment of the governor as well as removal of the governor should be based on consultation with the chief ministers. Sarkaria Commission. Then the Legal Services Authorities Act of 1987 provided their statutory framework to ensure the access to justice and the free legal aid, thereby strengthening the constitutional mandate of the equal justice. That is the statement 1 is correct. Then the act gives a statutory effect to Article 39A under DPSP to provide the statutory recognition for the Lok Adalats, People's Court, correct. Then the state legislative services authorities headed by the governor and members of the SCST is entitled to legal aid only if they satisfy the income limit is not correct. Legal aid for any persons who are required that. 1 is correct, 2 is correct, 2 is correct. Statement 1 is correct and 2 is correct. Option is C. Okay. Consider the following statement. Legal aid mechanism in India often face the issue of issues of effectiveness and public trust. Correct. They often face the issues of effectiveness and public trust. Correct. System largely relies on generalist lawyer with the limited incentives and institutional support. Correct. So that it lead to inefficiency in ineffectiveness in India. Both the answer is A. Consider the following statement. Legal aid delivery in India often suffers from the uneven quality and the limited public confidence. Correct. This is statement 2. This is partly due to the dependence on the panel lawyers with the limited incentives, inadequate training, and weak institutional monitoring. Correct. Same question repeating. Yeah. With 62, with reference to the constitutional morality, consider the following statement. Dr. Ambedkar said that the constitutional morality is natural to the Indian society. Not correct. If the constitutional morality is natural to the Indian society, means there is no need of constitution, codified constitution. India can be ruled without the. But Ambedkar would never say this. People of India need a constitution. That's why to save the Dalits from the people of the higher caste. That is his attitude. So now it was George Crote who states that constitutional morality is for constitutional forms and freedom to criticize authority. Correct. Supreme Court has applied the constitutional morality against the discriminatory social customs. Correct. Constitutional morality requires their judges to follow only the literal text, not the literal text alone, but can act on their conscience. 4 is not correct, 1 is not correct, and 4 is not correct. 2 and 3 are correct. Answer is B. With reference to the challenges to the constitutional morality, consider the following statement. Constitutional morality supports the viewing the constitution as a living document, living organic document. Correct. Judicial activism alone is the sole threat to the judicial activism is not a threat to the constitutional morality. Judicial activism is the act of the court in the domains of the executive and judiciary within the framework of the constitution. 2 is not correct. First statement is correct. So answer is A. With reference to the center-state fiscal relations, consider the following statement. Ending GST compensation has hit the manufacturing states more. Correct. So that the compensation given. Then the vertical imbalance is due to the mismatch between the revenue powers and the expenditure duties. Correct. Because the union has the power to levy and appropriate the tax, but the operational cost belongs to the state. So it is the vertical imbalance, fiscal imbalance. Cesses and surcharges are the part of divisible pool. Not correct. Cesses are levied for the particular purposes, they collected by the union and appropriated by the union. Surcharges are they to meet with the tax expenditure? Not correct. The interstate GST is shared between the union and state immediately. 4 is correct. Then 3 is not correct. 2 is correct. 1 is correct. 1, 2 is correct. 1 is correct. 4 is correct. 3 is not correct. Answer is C. With reference to the political development in the Ladakh, consider the following statement. Leh Apex Body and the Kargil Democratic Alliance are merged into political. Still, political party is not formed, but the movement is continuing there. Unrest is representing there. That is not correct. Job reservation and the recognition of the local languages are the part of negotiations with the union government. Correct. Then violence erupted following the rejection of the 6th schedule demand is not correct. The union government not rejected the 6th schedule, but negotiating with them. Civil society organization publicly claim responsibility. No civil society organizations in India claims responsibility, even it instigated the violence. C is not, 4th is not correct. 3 is not correct. 2 is correct. 2 only is correct. Answer is A. Ladakh, statement 1. Ladakh witnessed the renewed unrest despite a earlier agreement and dialogue with the union government. Correct. Environmentalist called as Wang Chu was also arrested. Divergent perceptions and the expectations between the union government and the local protest group contributed to the escalation of the tensions. Correct. Both are correct. Answer is both are correct and substantiate the first one. Okay. The answer is A. With reference to the proposals on the simultaneous elections, a single stage synchronization of the elections were proposed. Correct. Article 82A empowers the election commission to alter the tenure of the state assemblies. Correct. The laws of the union territory seeks to align the assembly terms, the term of the assembly with that of the Lok Sabha term. Correct. Then the newly elected legislature may serve. Newly elected legislatures may serve only to the remainder period for the synchronized term. Correct. Only if the simultaneous election comes, if the Tamil Nadu election in 2026, then in 2027, the simultaneous election comes. That means Tamil Nadu election assembly tenure reduced to 4 years, synchronized. Correct. No option. Okay. No option. Alternate options are not correct. Okay. Consider the following statement. The Committee on Final and Simultaneous Elections recommend that after a premature dissolution, the newly elected House should generally be given a full year term. Generally, I have given the correct. The recommendations was intended to prevent the re-emergence of staggered elections. Correct. Both are correct. With reference to the President rule, consider the following statement. Article 19 is not automatically suspended during the operation of the President rule. Correct. It requires a special order. Then the extension of the President rule beyond 1 year requires a national emergency and certification of the Election Commission beyond 1 year. It requires the certification of the Election Commission that the elections are not conducive there. Okay. Laws made by the President rule lapse automatically. Laws made during the President rule lapse automatically. Not correct. Parliamentary approval for the President rule requires the special measure, not a simple majority. 2, 3 not correct, 4 not correct. 3 not correct, 4 not correct. So answer is A. With reference to the Niti Aayog, consider the following statement. It was tasked with preparing a national Niti Aayog, tasked with preparing national investment charter. Correct. Then Niti Aayog makes the state anonymously supported the Operation Sindoor. Correct. Not connected with the Niti Aayog, but correct. It promotes the competitive federalism through the performance of indicators. Correct. Allocations of fund directly to the state, not the work of Niti Aayog. 1, 2, 3 are correct. Answer is B. Statement 171. Cooperative federalism in India requires the coordination between the union and state, but the policy linked funding conditions can sometimes create center state friction, correct. Policy linked funding leads to friction. For example, education policy, new educational policy, policy linked fund. Linking release of the certain grants funds to the compliance with the policy framework as national education policy has been the point of center state debate. Correct. Both are correct and substantiate the first statements. With 72, with reference to the methodology of recent state performance ranking, consider the following statement. The state performance ranking, economic and fiscal pillars received the highest weightage. Correct. Infrastructure assessment excluded the social indicators. Not correct. Governance was assigned as relatively lower weightage due to the measurement challenges. Not correct. The fiscal pillars excluded indicators related to the fiscal pillars cannot be excluded with the expenditure. With the expenditure, revenue and expenditure both constitute the fiscal pillar. It cannot be. Not correct. 4 is not correct. 4 is not correct. First one is correct. Second one is, first one is correct. Then the second one, infrastructure assessment excluded social. Infrastructure assessment, that is not correct. Infrastructure assessment excluded from the social indicator. So physical infrastructure assessment excluded. Correct. Governance was assigned a relatively lower weightage. In the question கொஞ்சம் ரிசர்வ் பண்ணும் அப்புறம் செக் பண்ணி ஒன்று ஃபேக்சுவல் டீட்டெயில்ஸ் கம். 73, with reference to the recent multidimensional state ranking study, consider the following. Punjab secured the top position in the infrastructure pillar. Even Punjab and Haryana tops in the infrastructure, power and railway. And Kerala ranked higher in the education, health, owing to the strong performance. Both are correct. Then with reference to the Waqf Act of 2025, Section 40 was deleted, ending the Waqf's unilateral power to declare the property as a Waqf property. Correct. That was that the right to declare a property as a Waqf property by the Waqf board itself is deleted. Comes under the Section 40 was deleted. Then orders of the Waqf tribunal can be appealed before the High Court. High Court. Previously, it cannot be appealed. When the Waqf tribunal given the order, it can be challenged only in the Supreme Court. Then Act codifies the Waqf by user. Act destroys the Waqf by user. Act abolished the practice of Waqf by user. Any property that was called as a user property, any property, in any property, a pillar was established and worship continue for generations. Worship any property based on the belief on the user. For example, some property in Hyderabad, a property in Hyderabad, which is stated that Aurangzeb horses stayed there, and a saint was buried there. A saint, any property, the problem starts with burying the Muslim dead man in a particular property and started worshipping. It become a property by user. Property by the user. That is called as Waqf property. In the previous act, that was abolished. Then Act excluded the Limitation Act of 1963 from the Waqf disputes. Correct. For the 1 is correct, 2 is correct, and 4 is correct. 3 is not correct. 1, 2, and 4. With reference to the reforms relating to the Waqf board, consider the following statements. Muslim created trust under the Indian Trust Act is different from the Waqf board. Waqf trust. Okay. That is correct. Act mandates inclusion of non-Muslim members in the Waqf boards. Correct. The government versus Waqf board land dispute is decided by the collectors, district collectors, chief revenue officer. Correct. The mandatory annual contribution to the Waqf board has been increased. Not correct. Not correct. So first one is correct. Second one is correct. Third one is the correct, and fourth is not correct. Answer is C. With reference to the decentralization and the local governance in India, consider the following statement. Local bodies faces a function funds mismatch. Functions of the local body expenditure and the funds that it got is mismatch. Sewage management is outside the 11th schedule. That's wrong. Sewage management is a part of the local administration. Shifting accountability to the, that is wrong. Panchayats are constitutionally barred from the open market borrowing. That is wrong. Panchayats can have the access to the open market through the to the CSR funds, to the bank credits. That is wrong. 2 and 3 are wrong. Central sector schemes funds supports the panchayat but reduce the fiscal flexibility. That is right. 1 and 4 is correct. 1 and 4 are correct. Answer is A. With reference to the unfinished agenda of decentralization in India, consider the following statement. Despite conformity laws on the State Finance Commission, the state level fiscal administrative decentralization continues. The power to the panchayats were not given in most of the states. Continues, correct. Reclassifying peri-urban areas. Peri-urban areas means a newly emerging urban areas, fast urban revolution going on in India. Newly emerging urban areas into the urban local bodies is suggested as an immediate government fix today. Correct. Correct. Both are correct. With reference to the Article 200 of the Constitution, consider the following statement. Withholding of assents by the governor obligates the resident of the bill to the legislature. Not correct. Governor's withholding the assent to a bill is not his obligation to send back the bill to the legislature. Identification of repugnancy with the central law removes the obligation to return the bill. Correct. If any law of the state legislature seems to be repugnancy with the central law, in which the governor is not obliged to remove the obligation, then reservation of the bill for the president is permissible even after the repassages of the bill by the state legislature. Correct. Withholding the assent permanently terminates the bill. Not correct. 4 is not correct. Withholding the assent to the bill of the state legislature by the governor is not amounted to the death of the bill. It's not correct. 4th is not correct. Then the first one is not correct. Then 2 is correct and 3 is correct. That is answer is C. With reference to the unfinished agenda of decentralization in India, consider the following. Despite the constitutional provisions for the decentralization, concentration of the administrative and the fiscal power at the state level continues to limit effective local self-governance. Correct. State Finance Commission has ensured adequate and predictable fiscal transfer to the local bodies uniformly, not uniformly across the states. Not uniformly across the states. Reclassification of the pre-urban area into the urban local bodies has been suggested as an immediate governance issue today. 3 is correct. 2 is not correct. 1 is correct. So 1 and 3 are correct. Answer is A. With reference to the international electoral practice, consider the following statement. Countries such as Pakistan and Bangladesh permits the candidates to contest the elections on the multiple consistencies as like in India. Allowing candidate to contest from the multiple constituencies may undermine the voter choice by causing the post-election vacancies requires the fresh elections. Correct. Both are correct. 81. Which of the following statement regarding the arrest of the chief minister is not correct from the constitutional perspective? A chief minister may be arrested under the law if it is a credible allegation of the criminal offenses exist. Correct. The arrest must comply with the constitutional safeguards and the due process of law. Correct. Such an arrest may raise the constitutional concern relating to the federalism, constitutional concern relating the federalism separation of power. Correct. If the state union government start arresting the chief ministers, means it leads to problem. Arrest does not require the legal. No, arrest requires the legal authorization. Authorization of the governor, authorization of the court may be carried out and cannot be carried out solely at the discretion of law enforcement agency. D is not correct. Answer is D. With reference to the bill reserved by the governor for the consideration of the president, consider the following statement. A bill reserved by the governor does not require the legal force unless the president grant assents. Correct. Constitution prescribes a mandatory time limit of the 6 months for the president. There is no time limit for the president. He can apply even the pocket veto. Okay. So 2 is not correct. 1 only is correct. With reference to the Tamil Nadu governor's case, consider the following statement. Reserving a bill for the consideration of the president after it has been repassed by the state legislature violates Article 200. Not correct. Governor can reserve the bill even after it has been passed again. Then alleged conflict with the UGC regulations justifies the bypassing of the state law. Correct. If the state government appointed any of the VC deviating from the UGC regulations, means governor can bypass that appointment. 2 is correct. 1 is not correct. Answer is 2 only, B. With reference to the article 371 to 371J, that is special provisions for the northeastern states. All the provisions under these articles contains the explicit sunset clauses. All the provisions, sunset clauses means the law, that means the law would become permanent with the effect of the day. That is not, the law can be changed. That is not correct. Parliamentary law relating to the land and customs of the people apply only with the state consent. Correct. The northeastern states. Only any parliamentary law that deals with the land and that deals with the social consent can be applied only with the consent of the state legislature. Correct. Article 31D, 371D and 371J aim to address the regional imbalance within the state. Manipur, regional imbalance. Correct. Special responsibilities conferred to the governor under these articles are revocable or the revocable. It cannot be revoked. The special responsibilities are given. So so parliamentary law to the land. 2 is correct and 3 is correct. 2 is correct and the 3 is correct. 1 is not correct and 4 is not correct. Then clean state doctrine under insolvency and bankruptcy code. Clean state means no liabilities. Clean state means no liabilities. A firm was given with a clean state from its debt obligations, means no liabilities. The old liabilities continued after resolution. Not correct. New owner is free from past liability. Clean. New owner is free from the past liabilities. 86B. With the 86, reference to the special constitutional provisions for certain states, consider the following statement. Absence of periodic review has contributed to the administrative and the legal asymmetry in the states in India. Correct. Such provisions invariably result in superior socio-economic. Not correct. Special constitutional provisions given to the northeastern states not created superior socio-economic outcomes there. Okay, not correct. 1 only correct. Cooperative federalism in India is primarily emphasized. Cooperative federalism in India primarily emphasizes a cooperation and collaborations between the union and state through constitutional and the non-constitutional agencies in achieving the development goals. C. With reference to the directive principles of the state policy, consider the following. DPSP are used by the court to interpret the scope and content of the enforcement of fundamental rights. Correct. DPSP is the end on the fundamental rights or the means to achieve. Then DPSP override the fundamental right in case of conflict. Not correct. 1 only correct. Which of the following is a prominent example of the cooperative federalism? GST Council, equal representation of union and the states. GST Council. B. With the constitutional provisions, which constitutional provisions support the right to clean and the healthy environment in India? Article 20. Article 21. Right to life and personal liberty. Article 21 deals with a right to have clean and healthy environment as a inferred rights. Right to have clean drinking water, right to have the clean environment, right to have clean air for breathing, right to have shelter. These are all inferred rights. Inferred rights, யூகிக்கப்பட்ட உரிமைகள். Inferred rights are rights not codified in the part 3 but enjoys the status of fundamental rights. 21. Which of the following parts of the DPSP? Which of the following parts of the DPSP articles are correctly matched? சொல்லுங்க. Article 39 equitable. Article 39 clause 2 and 3 deals with distributive justice. Distributive justice, that is lands, national resources, economy. Correct. Article 44 uniform civil code. Correct. 46. Okay. 39A. Correct. All are matched. With reference to the center-state relations, consider the following statement. Sound schedule demarcates the legislative powers between the union and the state. Legislative powers, administrative powers, and financial powers. Then a state law and a concurrent list of subjects prevails if it is revealed, if it has received the presidential assent. Correct. If the president, with the assent of the president, the state can legislate a law in the concurrent list. Scope of Article 356 has been judicially regulated. Yes or no, my case. Correct. All the three are correct. Fourth, negative marks. Interstate council are binding as a binding decision making. No, interstate council are the extra constitutional non-statutory bodies. Extra constitutional bodies are the non-statutory bodies to create a cooperative federalism. Not binding. That is the interstate councils were established to deal with the distribution of river waters, to deal with the administration of the linguistic minorities, then boundary disputes, mutual development. Then 93. Consider the following statement. Basic structure doctrine limits the parliamentary power to amend the constitution. Correct. Parliament can amend any part, but not to the extent of violating the basic structure. A basic structure doctrine ensures that the futures such as federalism, secularism, judicial review, and democracy cannot be abrogated by the constitutional amendment. Correct. Both are correct. Substantiate each other. 94. The discretionary powers of the governor has emerged as a significant source of the center-state friction in recent years. Correct. Tamil Nadu governor, Kerala governor. It was in recent years, throughout, right from 1967, with the advent of the opposition regional parties in the state, it became the problem. Constitution requires the governor to act independently of the Council of Ministers in all matters. Not correct. Not correct. Constitution states governor is the head of the state and who shall exercise his powers only on the advice of the Council of Ministers. Not correct. Not correct. 1 is correct and 2 is not correct. So answer is C. Consider the following statement. Judicial review strengthen the constitutional supremacy of India. Correct. Why judicial review? Why we need a judicial review? Judicial review is to reinforce the supremacy of the constitution. Judicial review empowers the court to examine the constitutional validity of the legislative and executive actions. Correct. Both are substantiating each other. Our Finance Commission plays a critical role in strengthening the fiscal federalism. Correct. It determines the distribution of the list and not financial powers. It is the financial powers. 2 is not correct. 97. In India, the right to have a clean and healthy environment is protected as a part of a right to life and personal liberty. Correct. Indian courts interpreted Article 21 to include the right to have the clean air and the safe drinking water. Correct. Our directive principles of the state policy, especially Article 48A, supports the environmental protection and has been used by the court to strengthen the environmental jurisdiction. Correct. All are correct. All are correct and substantiate the first statement. Consider the following statement, 98. Functioning of the GST Council reflect the cooperative federalism in India. Correct. GST Council is a constitutional body under Article 279A that provides a platform for the union and the state jointly decide GST-related matters. Correct. The decision of the GST Council is based on the consensus building and shared participation of the union and state in fiscal policy. Both, all are correct. That substantiates the one. 99. 99. Answer is A. 100. Answer is GST Council, Finance Commission, Interstate Council. So Interstate Council is a constitutional body that comes under Article 263 of the Constitution, but its statements are not binding. Okay, the recommendations are not binding. Okay. First test. This முதல் test எல்லாத்துக்கும் total. எவ்வளவு இருக்கும்? 50%. 50% வருதா? வருதா? Consistent of 50% above 50%. Best way. Okay. See you next. நாளைக்கு வச்சுக்கலாமா ஹிஸ்ட்ரி கிளாஸ்? ஓ,